Welcome to Cocktail Explainer, where we are dealing with the question of employee and employer. Today we are specifically looking at section 44, 45, 46, 47, up to 50 of the law of employment. Summary dismissal. What is summary dismissal? When you go and find that your boss has just told you, pack and leave, you have been summarily dismissed. What are the grounds for you to be summarily dismissed? And what is the procedure provided for in summary dismissal? Section 44 says, summary dismissal shall take place when an employer terminates the employment of an employee without notice or with less notice. So you are dismissed without notice. Or if your notice is 30 days, your employer gives you a notice of 2 hours. Surrender your tools of trade and leave. Get out. Pass and see the accounts office. If there's anything, you go. Do you know, in summary dismissal, you lose all the benefits. You have worked, imagine, for 59 years. You are now 59 years old. You have worked for the company for 40 years. You are due to retire. Next year, when you reach 60, you are a civil servant. You are summarily dismissed. You lose all the benefits. You have worked for a company for 10 years. You're expecting some gratuity and some terminal benefits. You lose everything. What is this monster called dismissal? That is summary dismissal. The law does not allow summary dismissal unless an employee commits the following. Listen carefully. If you commit any of these offenses, if you commit any of these breaches as an employee, you will be sacked on the spot. Summary dismissal. It says, if you are absent without authority, you go drinking on Friday, I know you are in Naivasha, you continue drinking after the safari rally, you don't come to work. That is enough ground to summary dismissal. If your employer is not aware where you are, he will or she will sack you on summary dismissal. Number 2, if an employee during working hours, by becoming or being intoxicated and rendering yourself unable or unwilling to work, drinking while on duty. And this is the biggest problem of the youth, of the very many employees that are in the market now. People are coming drunk to the office. Beer and whiskey is readily available. Young employees carry bags. They put their laptop inside. They put their cameras inside. They put their phones inside. They put whatever they put there. They hang them here. Inside is a bottle of whiskey. Inside is a beer can. They are drinking in the office. They come to the office drunk. They go out for lunch. They go, as they are eating their nyama choma, they take beer. They come back to the office. This is an advocate. He's drunk. He goes to court, addressing the court while drunk. If you are drunk in your place of work, that is what will take you home, called summary dismissal. Nobody will even bother with you. You will be sacked if you don't know drink. What is my advice? Drink after work. Leave the bar when it is a bit early to allow you to sleep and have a good rest for the next day. Beers and whiskey have been there since Jesus' time. You remember the wedding of Cana? Yes, Jesus made bread and there was wine. So beer will not go anywhere. It is you who will disappear. It is you who will wreck your health. But lastly, it is you whose drinking habits will make you lose your job. Very serious consideration. Fourth, if an employee willfully neglects to perform any work which it was his duty to perform, or if he carelessly and improperly performs any work which it was his nature to do. Refusal to do your job, neglecting to do your job. You are a doctor. You're supposed to go to the hospital to treat people. You don't. You are a driver. You're supposed to drive your boss. Instead of driving your boss, you don't appear. Or even if you appear, you do that work carelessly, contrary to what you are supposed to do. That can take you home summarily. 5. If an employee knowingly fails or refuses to obey lawful and proper command to do your duty, if an employee refuses to comply with the directions, lawful directions issued by the employer tells you, today, you're not going to this court, go to that court. Say, I'll not go to that court as an advocate. You are a journalist, you have been assigned, go and cover this story. Say, that one, I'll not go and do it. You are a driver, boda. You're told, today, take this parcel from industrial area to Westlands. You say, I'll not take that. You are a policeman. You have been told, you go and disperse this crowd. You refuse. Any disobedience of a lawful order, mark my words, the lawful order must be in line to what you do. Suppose your boss tells you, I want sex from you. Is it a lawful order? That is not a lawful order. Suppose your boss tells you, you are a man. Yes, go and shave your head bald. I don't want to see you with hair. I don't want to see you with beards. Today, all the young men have beards. Can your boss tell you, shave? That is an unlawful order. You cannot be ordered to shave your beard. Or women, don't come with braids. That is an illegal order. So you can only comply. If you fail to comply with a lawful order, you will be sacked. That is summary dismissal. The order of insubordination does not only need to come from your boss. Any supervisor ahead of you acts on behalf of your boss. If the CEO tells you do this, that is the authority given to the CEO by the boss. Any director, any supervisor, anybody who has lawful authority, any head of department, whatever he tells you, you must comply. Failure to which you have insubordinated the authority of the employer, and you'll have to go without notice. F. If you are arrested, and listen to this very carefully, many of you are arrested on Friday. You go to Milimani law courts. You are detained for 20 days. Do you know, if you are in police custody or in prison for over 14 days, you'll be summarily be dismissed. What does the law say? So that you know. It says, if the lawful exercise of any powers of arrest given by or under any written law, an employee is arrested for a cognizable offense punishable by imprisonment and is not within 14 days either released on bail or on bond or otherwise lawfully set at liberty. So when you see Wakili Omari fighting in court for people are employed to be released on bond within 14 days, if they are not released on bond, they are going home, what is called summarily dismissal. You know. Make sure if your relative is arrested, let the lawyers fight for him to be released within 14 days. If 14 days end and he is in lawful custody, he'll be dismissed. Lastly, if an employee commits or on reasonable sufficient ground is suspected of having committed a criminal offense against or the detriment of the employer or his employer's property. If you steal from your employer, you'll be summarily dismissed. If you destroy the property of your employer, you will be summarily dismissed. If you are in any way involved in any criminal act against the employer, you will be summarily dismissed. For example, you get the confidential files of your employer, you take them and give it to the enemy. You disclose business tips of your employer to somebody. You work against your employer by a criminal act, you will be summarily dismissed. So, under Section 44, those are the powers. But under Section 45, there is now what is called unfair termination. When does the law say where you have been terminated, the termination is unfair? This is the defense against termination without notice, summary dismissal. What does the law say? A termination of an employer, if an employer terminates an employee without A, if the procedure the employer used in terminating or dismissing the employee was unfair. What does that mean? Anytime an employee must terminate, there must be a notice issued to show cause. After the notice to show cause, the employee must be given sufficient time to defend themselves in writing. In the notice to show cause, allegations or accusations must be put there. The employee must respond. Then the employee must attend a hearing, a disciplinary hearing. If that is not followed, then the procedures that were followed were wrong. That termination, that summary dismissal will be declared unfair termination. 2, the communication of that decision to the employee. If a decision to summary dismiss has been made, it must be communicated in writing to the employee and in person. If it was not served, don't take a termination letter, summary dismissal to somebody's wife or somebody's husband. It must be served to the employee in person. Number 2, the conduct and capability of the employee up to the date of termination. Every time the conduct and what the employee has done, the track record, is it a one-off mistake? If it is a one-off mistake, he can be given or she can be given a warning. The court also will look at, is there existence of previous warning letters issued to the employee? The day you see your employer giving you a first warning letter, tomorrow another warning letter, a third warning letter, they are building a good case for your summary dismissal. My advice, when you see them following each other, resign and leave. It moves on to say, has the employee had previous cases of this nature? Lastly, how has the employer been dealing with such matters? So all those are issues the court will look for. The following cannot make you, Section 46, the following cannot make you be summarily dismissed. One, you cannot dismiss an employee on the purpose of pregnancy. If somebody is pregnant and you are summarily dismissed, that is wrong. Two, on the reason of an employee being on leave. Three, on an employee being a member of a trade union, excluding the KDF and police officers. Joining a trade union cannot make you to be sacked. And what about if you are involved in a lawful strike? If you join a lawful strike, the employer cannot sack you. But if you join an illegal strike, the employer can jail you. If you are HIV positive, can you be summarily dismissed because you are HIV positive, because you have developed a mental health, because you have developed some conditions? What does the law say? An employee cannot be summarily dismissed because of race, color, tribe, sex, religion, political opinion or affiliation, national extraction, nationality, social origin, marital status, HIV status, or disability. If you are sacked because you are single, or if you are sacked because you have now become married, that is not allowed. If you are now a Muslim, or you have changed from Muslim, you are a Christian, that is not a ground to terminate you. And lastly, if an employee participated in that. So what is the procedure to remedy summary dismissal? One, you must report either to the labor office and make a complaint to the labor office within a prescribed time, 3 months. So if you are sacked summarily, you must go to the labor office within 3 months. If you don't go to the labor office, then you will go to the labor court, the industrial, that is the employment and labor court, within the stipulated timelines. If you want to go to court, you must go to court within 3 years after you were sacked. Many people have been sacked, they have a labor issue with their employer, they sit for 10 years, then come to an advocate saying, take this matter to court. I have put it very clearly. A complaint to the labor officer, that is a government officer, is within 3 months. A case to court that about employment, the duration is 3 years. After 3 years, you can't go there to deal with that matter. When you go to the labor office, an advocate cannot represent you. You will go, the person who will represent you at the labor office is an officer from the trade union. When you go to court, your advocate, Wakili Dan Sinomari, will sue or defend on your behalf. What are the remedies available as provided for? What can the court give you? And the court in Article Section 49 and Section 50, the court can order you be reinstated. The court can order you to be compensated. The court can order, if you win the case, to have a compensation. So the courts will interfere where it is not always common for you to be reinstated your job. Mostly courts order for compensation because it is not possible. If an employer doesn't want to see you, you can be paid, because the court rarely compels employers to take you back, but the court will compensate you for all those vagaries that have been done. After you have been sacked and the sacking has been confirmed to be lawful, Section 51 provides that every employee after exiting work must be given what is called a certificate of service. What does the certificate of service contain? It contains the name of the employer and his postal address. 2, the name of the employee. 3, the date when employment of the employee commenced. 4, the nature and usual place of employment of the employee. 5, the date when the employment of the employee ceased. And lastly, such other particulars as may be prescribed. Employers, it is mandatory once you sack your employee to give that employee a certificate of service. Employees, ensure when you leave service, when you leave employment, you have a certificate of service as provided for. Wakili Dan Sanumari has brought to you the 5th episode that deals with summary dismissal. When will it become unfair termination? And what will the courts do if they find that it is summary dismissal? While in court or while in the tribunal, the burden to prove that you are wrongfully dismissed is on you. If you allege, you must give evidence. And the burden to justify why the employer sacked you rests on the employer. Wish you a good weekend. Keep your job. Keep your employees. Let us build this country, because our economy depends on employers and employees. All the best.